Welcome to Guardians of Innovation, Patent and Trademark Law.
Hello and welcome to Guardians of Innovation, Patent and Trademark Law, the podcast where we dive into the world of intellectual property and protect the ideas that shape our future with registered patent attorney Vincent LoTempio. In today's episode, we're tackling another crucial question for any entrepreneur, business owner, or creator. How do you choose the right trademark for your brand? With so many factors to consider, choosing a trademark can be a daunting task. So don't worry, though. Vincent is here to break it down and guide us through the process. Vincent, welcome back.
Hey, how you been? I really enjoy doing these with you. It's been a long time, but I appreciate you coming back and doing this with me.
Absolutely. I've been good. I hope you are too. And yeah, I'm excited to dive into some trademark stuff. So can you start by explaining what exactly a trademark does for a brand's protection?
Yeah, sure. I mean, I always tell people on the phone, look, it's like a sword and a shield. First, if somebody's copying you and stealing your mark, you have a sword where you can cut them off below the knees and stop them from doing it. And if someone tells you you have to stop using your own trademark, you have the shield and say, look, we're a registered trademark and you can't stop us from doing this. So, you build your brand recognition, which is vital, right? You want people coming to look for you on the internet. So once people know you and they're looking for the Thai Beanie Babies, I don't know if you remember that when my kids were young, the Beanie Babies, it had to be that specific brand. So brand recognition is vital, right? The legal protection that I told you about, once it's registered, it's going to stop people from being able to steal your idea. It's going to give you protection. It's going to stop other confusingly similar marks. And I think that's just an important thing that we should point out. A lot of people say, what happens if I just put the word "the" in front of it or put a space here instead of there, or change the S to a Z? Those are all considered confusingly similar. So if people just change it a little, and that's a false, impression. People say, what's the use of getting a patent or a trademark? If someone just changes it a little, they'll get around it. But that's not true. I always say, if you come to me and ask me, does this look too much like the Pepsi-Cola bottle? You already know the answer.
Yeah.
Right?
You've answered your own question. Yeah.
You already know, right? You don't have to ask me the question, right? So, when we register it, you're going to have exclusive rights. That's the bottom line. It's not absolute ownership, right? It's always a rebuttable. But it starts with there's a premise that you own it, and they have to rebut. So it's a rebuttable presumption that you own it. But and then after 5 years of a trademark, you can file what's known as statement of incontestability, where nobody can contest it. And there's always marks that can be contested, like the Redskins mark over a year if it's against the morals of the community or if you committed fraud to get the trademark. But once you get that registration, you're pretty much locked in stone, and it's going to be very hard for somebody to say that you don't own that after you've had it for 5 years and it's incontestable. So the whole idea of brand recognition is building goodwill in the community. And basically, even when we file an assignment, when you sell your trademark, it's not even a valid assignment unless you have the words transferring the trademark's name itself and the brand and the goodwill that goes along with it. So the qualities and values of that product. When you hear Cadillac, people use it all the time. It's the Cadillac of this. You think it's the highest level, right? So a strong trademark increases the overall value of the business. And again, it protects you against infringement and stops people from being able to stop you from using it and from saying that you're infringing on theirs because you're a registered trademark.
What role does the business's market or industry play in selecting a strong trademark?
What we want to do is we want to be able to appeal to a certain audience, right? So a strong trademark is something that comes up in the consumer's mind that gives you an idea like it's the best buy, right? For examples like, logos that are just sophisticated and just in your mind, you just see it, you recognize it. It's maybe, demographically, pertinent to your area, like the Buffalo Club in Western New York is, started with presidents. President Fillmore was one of the first members. So just hearing the name, you think that's a higher level, of the brand. It just elevates the brand just by having that. So it's not just saying, oh, it's a good product. It's the name in your mind, right? So it differentiates you from all the other competitors. When you hear, you could have a Chevrolet or a Cadillac right away. What do your mind tells you which ones you want to have, right? So those are certain, considerations that we consider when branding.
What is the process for conducting a trademark search, and how does it affect your decision when choosing a mark?
Certainly, we want to get something that's distinctive, right? So we want to identify marks or slogans that will separate you from everybody else. And when we do a search, I always say it's like A through H, all these different elements that the trademark office looks at. But we're going to search the databases all throughout the world, but specifically for the United States. You got to remember that trademarks like patents are local. What I mean by local is the whole country of the United States versus the whole country of Canada versus European countries, right? So depending on where you're going to be selling your product, that's where the search in the database that you're going to want to look at. So, we conduct thorough searches. We look for exact marks. I call that a knockout search, right? You're searching for a needle in a haystack. And you can keep searching for that needle forever, not be sure if you haven't found it. But once you find it, you know it. Here's the needle, right? So if we find the exact match, it's a problem. Let's get out of it. So then we look at similar sounding marks, and they call it phonetic equivalence. I've had people like the word clue versus the word cue. It's so close and so short that the other side, like Hasbro, didn't like the idea that we're using their mark for the word clue in selling a game, right? So we got similar sounding marks, similar looking marks, similar related services. When we're selling Big Mac hamburgers versus Big Mac trucks, there's no confusion, right? There's Domino's Pizza and Domino's Sugar, but if Domino's Pizza wanted to start selling sugar, salt in the sugar aisle, now we're talking that there's going to be some confusion here, and that's going to be a problem. So, and then, we check in our search, we check for status of marks. I've had marks that have gone dead and big marks, and because they stopped using them or they didn't register them. So, and we were able to jump in and grab those marks. So we want to make sure what the status of existing marks are. Now, not just that, we can look at similar marks that were rejected and why they were rejected and see if we will be rejected for the same reasons. They always say when you talk to the examiner, well, what about this one? They got it. How come we can't get it? And the examiner always says, look, every case is individual to itself. So we don't know what happened at the other one and why it did, and we're not even going to try to figure that out. But that's something that we want to look at prior to filing the trademark. The other part of it is, we look at a lot of trademarks and this is an example that happened to me. So one of my first cases, was probably 20 years ago. We're trying to register a flashlight with the word Viper X11. We file the application, and the trademark office says, yeah, it looks good. There's nothing else close. Nobody else is selling flashlights with the word Viper. And it turns out that Dale Earnhardt Jr. has a car called the Viper, and he doesn't care who or what, or his lawyers, I should say, who or what is using the word Viper. They're gonna contest it. So sometimes you could win the battle but lose the war, because it's going to cost you thousands of dollars to fight this, even though you're right. So sometimes I have to tell a client, even though you're right, we don't want to poke the bear here. Because like I said before, sometimes the bear eats you, sometimes you eat the bear. Most of the time the bear eats you. Let's avoid this. We can see this coming up front. My goal is to avoid problems before they happen. My goal is to keep you out of the courts, and my goal is to protect you before it happens. So those are all things that we look for when we do a search.
Isn't there a car, like a anti-theft company called Viper?
Yeah, I mean, like I said, if you look at how many different people have used Viper, and if I was smart enough at the time, which I was still learning, I would have looked and see how many different times the Viper was opposed. And when I did go look at it, finally, after we got opposed, I saw there was 20, 30 different companies that were using the word Viper that were opposed, and there was a lot that weren't opposed. And like I said, I call that a diluted mark, a weak mark, because so many people are using the same mark for different things. But at the end of the day, I can sue Walt Disney because it sounds too much like Vincent LoTempio if I want to sue them, right? But when I see that, Viper is suing 25 people, whether I'm right or wrong, I'm gonna tell my client, let's try to pick a different name. A lot of times it's too late because the client has already used the name and they spent all these resources to it.
Yep.
But in the beginning, before you've put one label on one product, that's the time you want to do it. You don't want to do it after 75,000 labels are on 75,000 cases of applesauce in the grocery store because you didn't do a simple search. That case with the applesauce is a true case.
Oh, that's a real one. Oh, okay.
It really happened.
Picking something at
I
random.
didn't just make that up. No.
What are some of the biggest mistakes you see business owners make when choosing a trademark?
Yeah, I think the biggest mistake is their ability not to look at those distinctiveness factors, right? And not going with the fanciful or arbitrary or suggestive marks and coming up with the descriptive marks. And they just want to describe exactly what it is. You can come up with a name that's very descriptive, American Airlines, and then it could become distinctive. But it was so descriptive, like open MRI, and they just don't want to get off that because they think that's what everybody's going to be typing in to look for them. But it's not a very strong name, and you're not going to be able to stop them from using it if it's overly descriptive until you can prove that you've acquired distinctiveness, right? And so acquiring distinctiveness means that you sold millions and millions of products and you got to that point. So I think that's the biggest problem. And, I think we want to pick strong, unique marks. We want to do a search so we can avoid conflicts, and we want to, assess the market effectiveness of what that is. And those are difficult things for small companies and entrepreneurs to come up with target audience appeal, a mark that will resonate with the market and convey the right message and easy to spell and easy to recall. Those are all simple things that you want in your mark. Well, the other thing is, marketing 101. I took some marketing courses. I have a finance background and a marketing background. And marketing 101 is brand consistency over and over and over. Use the same thing. And I find people using different trademarks and using their trademark with different colors and different ways. So we really want to establish the mark and using it over and over again. So at the end of the day, my job is not to pick the name so much. I could always go home and tell my wife to put the blue curtains up, and she's not going to do it. But I could tell her, look, if you put those curtains up, these are the legal problems with it, and it's they don't meet fire hazards or they're they're not legally available because they're going to create confusion in the market. And I can't really pick the name, but I can give you like parameters and how to pick the name. So, and you have to think about long-term, defensibility. Are you going to be able to choose a mark that's not only distinctive, but it's defensible? Mm-hmm. So if you're creating this descriptive mark, it's, Joe's Camera Shop, somebody named Joe, down the road that wants to open a camera shop, are you going to be able to stop them? It's just purely descriptive, right? So let's start off doing it the right way.
Yeah. And, you talked about marketing. I mean, you want to balance creativity, and distinctiveness when choosing a trademark for a brand. It's good. I think it's cool that you have a marketing background because it helps you to understand that the battle that people face. How do you advise, companies or business owners to balance that creativity with distinctiveness?
Yeah, that's a really great question. You want something that's memorable, very creative. And again, I'm not that creative person. I always say, it's going to pop in your mind when you're not trying to force it. So you want it to be unique, something unexpected that just sticks in their mind, right? Memorability, then clarity. So it's got to be clear, right? It's got to be, when they see it, it shouldn't be so abstract and obscure that it becomes difficult to connect to the brand's identity or the offerings. And uniqueness is that's the most obvious thing. If you just have the same mark as everybody else, or it's so close to everybody else's, again, we talked about distinctive trademarks, how are we going to stop confusion in the marketplace when people come directly to you? So it has to be unique. All those things help with protecting it, right? And we want to make sure when we do our search that we can protect it. So we want to avoid those generic terms or overly descriptive marks because they're very difficult to protect. So great trademarks, like you said, strike the right balance between creativity, memorability, distinctiveness, while staying aligned with the brand's identity and values.
How do you, as an attorney, as a trademark attorney, help the selection process and ensure that the mark is protected properly?
Yeah, like I said, I try not to get involved, because even when I suggest like a name, with the creativity part of it, that's going to be up to you. I stay on the legal side of it. So my job is to conduct a comprehensive search so that we're sure that you have a chance of getting it, right? We want to avoid legal conflicts and costs of rebranding later on. We want to get it right the first time. So our search is going to tell us whether or not someone else is going to fight for this and accuse you of stealing their idea. So we'll look at all the similar marks and evaluate them, whether they're identical, whether they're phonetic equivalents, whether they're going to create confusion in the marketplace. Those are the types of things that I can tell you right off the bat, right? So, I'm going to guide you, to select the marks. We want to start with a strong mark. We want to be at that top of the scale of arbitrary and fanciful and suggestive, and we want to stay away from descriptive and generic marks. I mean, over and over, it's the same thing. I'm going to help you fill out the application. And I keep saying I'm going to register as a trademark. It's more than just filling out the trademark application. It's all the legal advice that goes along with it. I can fill out the trademark application, great, but if you don't have the proper specimens, if you're not using the trademark properly on your website or on your labels and your tags, anything I put in or anybody that's going to do an application is going to do it wrong. And that's why when I want to name names like LegalZoom or some of these companies, they'll say they'll do it for $89. Essentially, all they're doing is filling out the form. Anybody can fill out a form, but you need a lawyer to help you with the legal advice that all the underlying facts that go into the form are taken care of prior to filling out that form. And so, my job is to make sure that everything behind the scenes is done right before we go and we do it. So I'll give you strategic advice on how to use the mark in commerce, how to put labels on your products, how to use it on your website and your advertising. And then, of course, once we file the application, who speaks the language, better than a lawyer to another lawyer? These examiners are all lawyers, and I understand what they're looking for and focus in on it. And a lot of times, the guy that's just filling out the form or the consumer doesn't understand what the problem is even. And some of the problems aren't even problems; they're just simple understanding of how the system works.
Right.
So who's going to work with them once we have a problem? And we've had, I always say, and I don't want to brag, that we get like 98% on trademarks, right? After we've done the search and we've given opinion. There's always things that slip through the cracks, but it's pretty high once we've done our search. We have a pretty good feeling for it. But there's always something that the examiner sees differently than you, or something might have slipped through on the search that was close that we didn't think was important, but it turns out to be the examiner thinks it important. So when we go to have this conversation with the examiner, we can sit down and talk their language and talk it through. And sometimes, they dig their heels in and there's nothing we can do. And there's other times where we change their mind, based on communication and working our way through it. There's a case that we had, it was a one-man band. His name of his band was Hey Man. Hey Man, how you doing, Hey Man? And we registered him from a band. There was no other bands that had that. And the patent office rejected it and said, well, there's a t-shirt company. And all bands, have t-shirts. So maybe people will get confused with the t-shirt company called Hey Man. I said, well, look it, all bands have t-shirts, but no t-shirt companies became bands afterwards.
Right.
And the examiner on the phone said, hey, you're right. You're probably right. And then he changed his mind right on the phone. It was just a simple argument. So sometimes speaking their language and making these things is what you need. You need a mouthpiece, and that's why you hire a trademark attorney.
It's like our future band, Vincent, Free Beer. That's always the best name, right?
Yeah.
You always have a great audience.
Let me do a quick search. My mind goes right away. I got to go search the trademark.
All right. Well, thanks for joining us on Guardians of Innovation, Patent and Trademark Law with registered patent attorney Vincent LoTempio. If you'd like to connect with Vincent, visit LoTempiolaw.com, and please be sure to like and subscribe to our channel and leave us a review. Vincent, always great to see you. Thanks so much.
Hey, thank you. And call me if you need anything.
You bet I will.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.